Our first annual DC LERA Labor Law Forum. My name is Patrick McHugh. I'm Associate Professor of Management at George Washington University. I'm pinch hitting today for Steve Slay, who's the current DC LERA chapter president. He couldn't be with us today, so I'm just kind of filling in for him and kind of welcoming you all here. Again, like I said, this is our first annual DC Labor Law Forum, and certainly hope that it will not be the last. And I anticipate that we will try to make this at least a yearly event where we gather experts in the area talking about some hot button labor and employment law issues. Really a great way to conclude our series of events for DC LERA. And just as a reminder, before we move towards our panel, is that in the fall we do plan to have a series of events, and the first one I'd like you to mark your calendars for September 14th at 5 p.m. On an in-person event is what we anticipate, and this will be at the Washington D.C. office of the ILO. Where we'll be showing the film 9 to 5. So mark your calendars for that, and we'll be sending announcements about that. So I would like to welcome our speakers today, but Tequila Brooks, who is another member of our board and who coordinated this session, I'm going to pass the baton to her for introductions and maybe an explanation in terms of the format of our event today. But again, welcome to DC LERA.
Thank you, Pat. Can you hear me? Thank you, Pat. I wanted to welcome everybody to the first DC LERA Labor Law Forum. We have an excellent panel of leading practitioners and scholars to discuss some of the key labor law issues facing workers today. We'll start off with Tonia Novitz, who will speak to us about an exciting decision by the UK Supreme Court on the classification of Uber drivers. Then we'll move on to Matt Ginsburg, Associate General Counsel with the Afl-Cio, who will talk about some legal developments at the state level in the United States on the classification and legal frameworks applying to gig workers in the gig economy. And finally, we'll move on to Mark Gaston Pearce of the Georgetown University Law Center Workers' Rights Institute, who will speak to us about using university procurement to ensure the safety and equity rights of workers in global supply chains. So I'm moving on. Here is our agenda for today. As you see, Pat has already spoken and I'm giving a few remarks. I'll give you a little introduction to Tanya, and then she will speak to you about the UK Supreme Court from February of this year. Then I will speak to you a little bit about the biography of Matt Ginsburg, and he'll give his presentation on US state level proposals to extend worker rights to app-based workers. And finally, I'll introduce Mark Pearce, who will speak on ensuring workplace safety and equity through university procurement. After our speakers have, after the presentations, we'll have a moderated roundtable. You can submit your questions through the question button in Zoom, and we'll pose them to the speakers and have them answer them. So to begin, Tonia Novitz is Professor of Labor Law at the University of Bristol Centre for Law at Work. She is a graduate of the University of Canterbury in New Zealand and Balliol College, Oxford. She has held fellowships at the International Institute for Labor Studies in Geneva and the European University Institute in Florence, Italy, as well as the University of Melbourne and the University of Auckland. She is currently chair of the steering committee of the International Labor Law Research Network, which is holding a conference at the end of this month. She's a UK representative on the advisory board of International Lawyers Assisting Workers and a vice president of the UK Institute of Employment Rights. Her research interests encompass labor rights, collective labor voice, international and EU trade, sustainability, and migration. Thank you, Tanya, for joining us from Bristol, England, and we look forward to hearing your comments and remarks.
Many thanks, Tequila. Just bear with me for a moment while I see if I can bring up my presentation. Okay. Can everybody see that?
Yes.
Oh, wonderful. Thank you. So I'm very much looking forward to these discussions. This seems like an excellent way to compare and contrast the legal issues which affect non-standard workers in the US and the UK. What I thought might be of interest to this audience is a significant gig economy case recently decided by the UK Supreme Court concerning Uber. Gig work is by no means the only non-standard work on offer in the UK. 0 hours contracts remain rife. Poverty for those in work for various reasons is growing. But platform work is notably increasing. And I'm not sure if you've seen the same in the US, but certainly crowd work has increased with the attraction of working from home during the pandemic. And we've seen a lot of app-based, task-oriented work. Delivery apps in particular have been popular during COVID-19 times. So this unanimous judgment, which was delivered by Lord Leggett in a court of 7 Supreme Court justices, was really significant. It sends a warning to those who wish to use complex contractual documentation to evade statutory obligations which would otherwise be owed by employers to their workers, even in the context of the gig economy. So what were the facts in Uber? Well, the Supreme Court judgment begins by very carefully setting out the particular facts of the case, how the app works, how the business model works, and the paperwork. So what becomes immediately apparent is that this is not just a local or even national dispute. It is very much transnational. So the appellant in Uber was a Dutch company, Uber BV, which held UK copyright in the Uber app. Use of the app was then licensed to 2 affiliate subsidiaries. One was Uber London Limited, which had the license to operate private hire vehicles in London. And another subsidiary is Uber Britannia Limited, which operates these vehicles outside London. All the Uber companies were emphatic that they were not employers. They claimed, and I believe this is a worldwide trend, they claimed that they were only acting in an intermediary role between the drivers and their clients. They were just a booking agent. It can, of course, be observed that Uber is not originally a Dutch model, but originated, of course, in the US, where the concept was first put into action in San Francisco in 2009. In any case, the operational workings of Uber were determined outside the UK, and curiously, the written contracts that were signed by the drivers were with Uber BV in the Netherlands, not Uber London. The passenger paid the fare to Uber BV, not Uber London, and it was also Uber BV that paid a weekly sum to the drivers, dependent on the rides they gave and their prices. The paperwork declared the agreement between the drivers and Uber was to be governed by the law of the Netherlands and unless otherwise resolved, any dispute was to be referred to arbitration under the International Chamber of Commerce arbitration rules. Now, ultimately, both the Dutch company and the UK subsidiaries accepted UK jurisdiction, but they argued that Dutch law should govern the driver's contract so that they had no protection under UK employment legislation. That view was ultimately rejected from the Employment Tribunal all the way up to the Supreme Court on the basis that the reality was that Uber London was the employer. Despite all the paperwork, the reality was different. So I think it's revealing of the kind of transnational model that was at play here, the use of a transnational arbitration clause, gig work being managed from abroad. But also I think it's really interesting that the judgments in these Uber cases were adamant that the paperwork would not be seen to reflect the reality of who had day-to-day control over the activities of the Uber drivers and profited from their labour. Now, as my colleague at Bristol, Professor Alan Bogg, has so eloquently put it, to accord primacy to the written contract would, in effect, be to invite powerful contracting parties to opt out of the statutory labour standards that ought to apply to the work arrangements. This would subvert the statutory purpose of protecting individuals who were vulnerable to contractual exploitation. And throughout the judgment, the Supreme Court appeals to the notions of control and vulnerability. So to give you an example, and this is at paragraph 71 of the judgment, it says, the general purpose of the employment legislation is not in doubt. It is to protect vulnerable workers from being paid too little for the work they do, required to work excessive hours, or subjected to other forms of unfair treatment, such as being victimized for whistleblowing. This was a case that was brought by Uber drivers, many Uber drivers, and they had been hired through a smartphone app which was provided by Uber. Now, their case was originally brought in 2016 before the Employment Tribunal, and that Employment Tribunal hearing focused on the circumstances of two test claimants, Mr. Yassin Aslam and Mr. James Farah. And I'll come back to the role of unions later, but I think it's worth noting that they are now respectively president and general secretary of a new trade union, the App Drivers and Couriers Union, but more on that later. So their claims concern their rights under the UK National Minimum Wage Act 1998, rights under the working time regulations, including the right to paid annual leave, and the rights of Mr. Aslam as a whistleblower who had made a protected disclosure. Now, they could only claim these rights if they were workers under UK law, in particular what we call Lim B workers. And I just want to take a moment to explain what that means. So why does employment status matter so much in the UK? Why was there this whole Supreme Court case focused on this? Why have there been several? Well, the UK distinguishes in law between independent contractors who are in business on their own account. They're covered by law, but not employment law, and employees and workers. So the idea of a worker is very much one created by the courts through their jurisprudence under common law. The notion of an employee or a contract of service dates from the days of masters and servants. It is a concept that has been recognised by statute, in particular section 230 of our Employment Rights Act of 1996. But really, all that statutory provision does is refer back to who is an employee. It's someone hired under a contract of service. What is a contract of service? That's defined by common law, and the courts use various factors or tests to determine whether holistically someone really is a servant under the control of a master under a contract of service. And the sorts of things that the courts will look for are control, mutuality of obligation, personal service, integration, variety of factors. And these employees are the most protected. They are notably protected against dismissal, both at common law in respect of what we call wrongful dismissal, but also more importantly under statute with provisions relating to unfair dismissal and redundancy protections. Being an employee is the best thing that you can be in terms of reaping the benefits of common law and statutory protections. Workers are a statutory construct. All employees are workers. Every provision, statutory provision defining who a worker is, says employees are workers. But also, some people will be hired as what we call Lim B workers, even though they are not employees, and they'll get particular legal protections. For example, the minimum wage and working time at issue in the Uber case. Also, really importantly, they can get access to trade union rights and protection from discrimination. And how do we tell who is a worker? Well, normally the statutory test essentially says you need a contract, personal service, and you need to be performing work for someone who is not your client or customer. There are lots of different definitions in different statutes. Section 83 of the Equality Act 2010, Regulation 2 of the Working Time Regulations. But as we'll see, what is so interesting about the Supreme Court judgment is it says essentially workers are all the same, Lim B workers are all the same, and the same kinds of tests have to apply to them. What is also important here is that many of our protections for workers are derived from European Union law, working time regulation and discrimination particularly. Now, EU law, by virtue of certain judgments of the European Court of Justice, requires also subordination. And these tests are all melded together in the Uber case. Before we get on to Uber, we need to go back to 2011 and a really significant judgment of the Supreme Court in a case called Autocleanse and Belcher. What this case did when looking both at employee and worker status said that the courts should look beyond the bare wording of the written contractual documentation, because that can be just a sophisticated attempt to evade legal liability as an employer. So despite submissions to the contrary, the Supreme Court were adamant that tribunals and higher level courts can and should look at the true or real agreement reflected in the actual working practices. And they should be free to do so where this pointed to employee or worker status. So it was acknowledged in Autocleanse that the contractual documentation can simply be a sham. It may be entirely inconsistent with how the contract is carried out in practice, and in order to decide who is going to be treated as an employee or worker, we don't just look at the written documentation, we look beyond that. Now, this idea of looking beyond the written contractual documentation was revisited in the Uber judgment, and that judgment by Lord Leggett goes even further. It sets up a statutory purposive test for workers, and the explicit aim is to protect vulnerable workers from low pay, excessive hours, or unfair treatment. As I said before, it unifies the Lim B worker test, and in doing so cites Guy Davidoff's A Purposive Approach to Labour Law, his book published by Oxford University Press in 2016, in particular, chapters 3 and 6. So Lord Leggett's judgment is concerned with what he calls the features of work relations which give rise to a situation in which such relations cannot safely be left to contractual regulation and are considered to require statutory regulation. This point applies to all the legislative regimes relied on in the present case, and no distinction is to be drawn between the interpretation of the relevant provision as it appears in the Working Time Regulations, the National Minimum Wage Act, the Employment Rights Act. He goes on to say in paragraph 76, once this is recognised, it can immediately be seen that it would be inconsistent with the purpose of the legislation to treat the terms of a written contract as a starting point in determining whether an individual falls within the definition of a worker. To do so would reinstate the mischief that the legislation was enacted to prevent. These laws were manifestly enacted to protect those whom Parliament considers to be in need of protection, and not just those designated by their employer as qualifying for it. It was observed that the Uber service agreement was presented to the drivers containing terms and conditions they simply had to accept to take up work, and that could not be determinative of their status as a worker. Instead, the conclusion was reached that the drivers worked for and under contracts with Uber. And here the Supreme Court pointed to the subordination or control manifested in that relationship. And they identify a list of factors from paragraphs 94 onwards. Lots of these will be familiar to you, but remuneration paid to the drivers was fixed by Uber. Contractual terms were dictated by Uber. A driver's choice to accept rides was constrained by Uber, which retained discretion as to who should take the ride and managed all the information. The driver's rate of accepting rides was monitored and affected access to future work. Controls were applied as to how the service was delivered, and the rating system manifested control, and Uber could terminate access to the app on the basis of the rating system. Communication between the driver and the passenger was kept to a minimum. An invoice was never sent by the driver to the passenger personally. And so the conclusion was reached that drivers were entitled as workers to the statutory protections that they sought. In addition to this, they were entitled to be paid when logged into the app and available for work, regardless of whether they were actually providing a ride at the time. Now, this litigation would never have occurred without the UK unions who were involved. The GMB describes itself as the union for Uber drivers, and the GMB launched the litigation. The Independent Workers' Union of Great Britain, the IWGB, through its United Private Hire Drivers branch, led Uber strikes, for example, in 2019 through an app boycott for 9 hours. And the leading claimants in Uber, Yassine Aslam and James Farah, are respectively the President and General Secretary of a new App Drivers and Couriers Union, the ADCU. Now, only the GMB is a member of our Trades Union Congress, the TUC, the National Association of Trade Unions. The IWGB has been incredibly active in terms of leading industrial action and strategic litigation, really significant in terms of British industrial relations. Doesn't sit within the TUC at the moment, and neither does the ADCU. How then did Uber react? Well, there was initially an infamous press statement. Uber turned up and said, well, we are very happy to compensate the litigants in the Uber litigation, but not the other Uber drivers who are now hired on very different terms and conditions to 2016 when the action was initially launched. Uber then said, well, we might be prepared to extend the national minimum wage to all drivers, but we think that we can only extend the national minimum wage to those drivers and allow them paid annual leave on the basis of the rides that they actually perform. because it's now possible to engage in multiple app logins, we don't think we need to pay when the driver is logged on to the Uber app and available for work. The IWGB was furious and issued a statement very early on saying that the Revenue and Customs, HMRC, now needed to enforce the Uber Supreme Court ruling on unpaid waiting times. And they said that the company was still taking drivers for a ride. They pointed out as well that there were concerns around the health and safety practices that were taking place in relation to PPE during the COVID pandemic, and they referred to their own litigation which had taken place in November 2020, whereby they had raised the issue that Uber drivers were not being provided with PPE when they were giving rides. So IWGB is asking for further intervention, and Uber seems to back away at this point and say, well, we need to neutralize the trade unions. So what do? They voluntarily recognize the GMB and say they will enter into collective negotiations with the GMB. They haven't reached an agreement yet, but Uber has said they will enter into negotiations. So the GMB does have past form on this. The GMB had entered into a collective agreement with the Hermes delivery company previously on the basis that the couriers were independent contractors. But the collective agreement said, yes, they're independent contractors, but they can claim certain rights regarding pay hours and holidays. That was back in January 2019. In the GMB press statement, it's noted that Uber is formally recognizing the GMB. It's a voluntary recognition, which means opening up negotiations. It also blocks access to the statutory procedure for trade union recognition for other unions. You would have to get GMB derecognized before, say, the IWGB could ask for recognition and entry into collective bargaining negotiations. This would enable the GMB to represent up to 70,000 Uber drivers across the UK. The drivers would retain the freedom as to whether or not to actually join the union, but the agreement does involve access rights for the GMB. The GMB will be able to go to driver hubs to meet and support drivers. There will be discussion working together on key topics: national earnings principles, pensions, discretionary benefits, including AXA insurance for sickness and injury, and a driver loyalty program being put in place by Uber, health, safety and well-being, responding to the IWGB's concerns, account deactivations, and regular representation, meeting quarterly to discuss issues. So no collective agreement yet, but still significant. Now, the App Drivers and Couriers Union, and remember, this is where the litigants in the Uber case are represented and are currently acting as General Secretary and President, refused to engage directly in bargaining with Uber. They responded to the recognition agreement with GMB by saying, we believe closer trade union engagement with Uber management is always a welcome development, but there's good reason for workers and their unions to be cautious. They noted that Uber applied for declaratory relief in the High Court to confirm that its business model was not in violation of transport regulations, despite commentary suggesting the opposite by Lord Leggett in the Supreme Court ruling. The ADCU intends to intervene in that case to defend our members who have sought protection from the Supreme Court. They also say, and this might be interesting for this audience, We are disturbed by Uber's divisive and anti-union behavior in the United States, most recently in California and New York State, where Uber has used the appearance of blunt collective bargaining agreements to actually weaken the power of workers rather than the opposite. Naturally, we have concerns about Uber's motivations on this side of the Atlantic, not only in the UK, but throughout Europe also. So they say it's a step in the right direction, but there are significant obstacles in the way of ADCU reaching a similar agreement. And they say for us, compliance with legal minimums should be the point of departure for any union agreement with Uber. In other words, we would prefer to rely on our statutory rights. There is further litigation taking place in the UK at present, and the Supreme Court's purposive approach in Uber may really help those engaged in app-hired task-based work. So there is a case currently before the Court of Appeal on Deliveroo, and the crucial question is whether the IWGB will be entitled to apply for statutory trade union recognition despite a substitution clause that Deliveroo put into its delivery couriers contracts at the last minute. In the Court of Appeal, John Hendy QC tried to rely on ILO recommendation number 198 to argue that a lack of personal service for some of the couriers shouldn't be a block to trade union recognition. And it is interesting that the Court of Appeal in the National Union of Professional Foster Carers case has adopted John Hendy's submissions and agrees that the ILO recommendation number 198 can be used to show that failure to satisfy one element of the worker test may not be decisive. There is also the Pimlico Plumbers case, which says that you only need to think about whether personal service is a dominant feature of the contract. It doesn't need to be solely provided by the worker in question. And hopefully a purposive approach, as advocated by the Supreme Court in Uber, will affect what happens in Deliveroo. So, to summarize on Uber, it's a case that challenges a transnational business model. It may have implications abroad. It enables a purposive test of statutory interpretation for vulnerable, subordinate, and dependent workers, less likely to assist your professional gig economy worker, but still an improvement on what we had. It responds to aspects of control rather than choice in the gig economy. But it also raises some significant issues around the reality of enforcement of court judgments and the need to recognize the significance of social actors, especially trade unions. So we need to think about whether the courts and unions operate here in helpful ways symbiotically to enforce statutory rights, or is perhaps the current configuration of activity on this issue unsustainable in the UK? Is further legislation crafted to the gig economy a better way forward? Or perhaps should we be looking at other regulatory tools? And so I'm very much looking forward to hearing what others have to say in this session. Thank you very much.
Thank you, Tanya, for that excellent presentation. And it segues into our presentation by our next speaker, who is Matt Ginsburg of the Afl-Cio.
Great, thank you.
Oh, let me give you people a little bit of background about you, Matt, before you speak. Matt is Associate General Counsel at the Afl-Cio. He represents the Federation and its affiliate unions in cases of enforcement in the federal courts of appeals. He files amicus briefs in the US Supreme Court and in other fora. He works on key and emerging legal and policy issues, including labor law reform, worker misclassification, and the gig economy, as well as the rights of immigrant workers. He provides training for union-side labor lawyers through the Union Lawyers Alliance. And prior to joining the Afl-Cio, Matt was an attorney with a union-side labor law firm, Cornfield and Feldman in Chicago, Illinois. He was also a Gadden Fellow and a staff attorney with the Chicago Lawyers Committee for Civil Rights Under Law. Thank you, Matt, and we look forward to your remarks.
Thank you, Tequila. Appreciate it. And thank you for the invitation. And it's always a little hard when you're on these Zoom presentations and not knowing exactly who your audience is. So I'll do a little bit of more introduction than I might otherwise. So I'm a lawyer at the American Federation of Labor and Congress of Industrial Organizations, which is the National Labor Federation in the United States. We're made up of 55 affiliate unions representing workers in all industries across the country, approximately 12.5 million workers who we represent in those affiliate unions. With that introduction, I want to also thank Tanya. That was a really fascinating presentation, and I'm particularly grateful to her because she, through her presentation, really provides a helpful framing for my topic, which is the labor regulation. The regulation of the labor relations and employment responsibilities of app-based companies like Uber and Lyft in the United States, as opposed to the UK, with a particular focus on the recent state-level proposals to extend collective bargaining rights to app-based workers, which Tanya noted at the end, particularly in reference to New York. This issue has come to special prominence this year after the app-based companies were successful in having California's Proposition 22 passed, and I'll talk a little bit more about what that is in a second. And it also has led most recently to this highly publicized proposal in New York to extend a form of quasi-collective bargaining to drivers in that state. But before I get into the details of those collective bargaining proposals, I want to first provide some background on the question of employee status as it pertains to app-based drivers generally in the United States. The issue is employee status legally and why it matters for this discussion. And the key point, and those of you from the US, I'm sure know this, but I wanted just to spend a few minutes on it, is that virtually all workplace protections in the US are tied to employee status. So whether you as a worker are entitled to minimum wage and overtime, or unemployment compensation, or protections from discrimination in the workplace, or whether or not you have a right to form a union at all, depends on whether you are classified as an employee rather than an independent contractor. And unlike the case in the other countries, including the UK, this is a binary analysis. Looking at my notes here from Tanya's presentations, we don't have limb B workers as are referred to in the UK. So you are either an employee or you are an independent contractor. There's no third category of workers or dependent contractors or limb B workers in the US. And despite this seeming simplicity of this binary analysis, what makes it actually very complicated is that the different workplace laws, both at the federal and state level, all contain their own definitions of what it means to be an employee. So it's possible for a worker to be an employee under one workplace law, but an independent contractor under another. And just to give a couple examples, at the federal level, the Fair Labor Standards Act, the primary law regulating wages and hours, utilizes a test for employee status that is broader than the common law and focuses on the economic reality of the relationship between the company and the worker. In contrast, the National Labor Relations Act, the primary federal law regulating labor relations, utilizes a test for employee status that's based on the common law agency test. So in this way, it's sort of broadly analogous to the distinction that Tanya was discussing between a reality-based test and a test that's more based on common law principles, in this case, common law agency principles. So other federal and state laws utilize these tests or a variety of other similar tests for employee status. And of particular note, what's broadly thought to be the most protective of these tests is known as the ABC test, which is used currently by some state workplace laws. And I'm going to take a minute to talk a little bit about the ABC test because it becomes important in some of these later conversations about the collective bargaining proposals. So under the ABC test, a worker is considered to be an employee and not an independent contractor unless the hiring entity meets all three conditions of the test, the so-called parts A, part B, and part C. And those three conditions are that A, the person is free from control and direction of the hiring entity in connection with the performance of the work, both under the contract and for the performance of the work and in fact. B, the person performs work that is outside the usual course of the hiring entity's business. And C, the person is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. And that's a lot of words, and I can come back to it if people have specific questions, but I think the key aspect of the test is, unlike the common law test, it creates a presumption that workers are employees unless the company can show all three of these A, B, and C elements. So there's a strong presumption of employee status. And again, this ABC test already exists in some state law, in state employment laws, and is very much part of many of the proposals that are being discussed now, and that I'll get into a little bit later. So against this background of the existing law, which has this binary between employee and an independent contractor, and where the specific test varies quite a bit, the employment status of workers for app-based companies like Uber and Lyft, and in particular their claims, as Tanya has explained, which are just as vociferous here as they are in the UK, that their drivers are independent contractors and not employees. This question of employee status has been the subject of repeated legal skirmishes in the US, both at the federal and state level, and both in private litigation, where private parties are bringing suit under state and federal laws, particularly wage and hour laws, and also through federal enforcement by federal labor agencies. And there's been a lot of back and forth here, not the least because of the change of federal administrations in 2016. So just to illustrate, for example, prior to the 2016 election, the US Department of Labor had issued guidance tightening up on the definition of employee under the Fair Labor Standards Act, our federal wage and hour law. And the Obama era National Labor Relations Board had issued a decision revising its interpretation of the employee status test. And at the time of the 2016 election had several unfair labor practice charges pending before it that raised the specific issue of the employee status of app-based drivers. However, after the 2016 election, the new Secretary of Labor withdrew the Obama era DOL guidance on employee status, and the new NLRB issued a decision that overruled the Obama era employee status decision. And then applying that decision, the NLRB's general counsel, the prosecuting attorney of the agency, issued an advice memo that specifically concluded that Uber drivers are not employees for purposes of the NLRA. So we've had this back and forth with the change of administrations. With the Biden administration now in office, it's widely expected that things are going to change back again. So at the US Department of Labor and the NLRB, it's likely we will see efforts to return to the approach of the Obama years. At the NLRB in particular, we're in a bit of a holding pattern because we don't yet have a confirmed permanent general counsel. And because of the way our National Labor Relations Board is structured with staggered terms of board members, we won't have a majority Biden appointed or Democratic appointed board until August at the earliest of this year. So we haven't seen those changes yet, but they are widely expected. In addition, the PRO Act, or Protecting the Right to Organize Act, is a broad labor law reform proposal which has passed our House of Representatives and is now pending in the Senate. That law, or that proposed legislation, which would amend the NLRA in a number of different ways, would replace the common law agency test of the definition of employee status under our labor relations statute and replace it with the ABC test, which would have clear implications for app-based drivers and their coverage by our federal labor relations regime. But as with many pieces of legislation right now in the United States, it faces very uncertain prospects in our closely divided or evenly divided Senate. So with that federal background in place, I want to move to the state-based proposals. And the reason I've spent the time to talk about the federal background is the state-based proposals and how we think about them are very much tied into what's going on at the federal level. So while all of this back and forth has been happening federally, there's been a tremendous amount of activity around regulating the employee status of app-based drivers at the state level, in particular in California, our largest state. This began in 2018 with a California State Supreme Court decision in a case called Dynamax or Dynamax, I guess is the correct pronunciation, which held that the ABC test, rather than something more akin to the common law test, should be used to determine employee status for purposes of that state's wage orders. So this wasn't a case about app-based drivers in particular, but did hold a broad ruling that in general, the ABC test should be used to determine employee status for at least this one state wage law. The following year, the California legislature enacted Assembly Bill 5, or what better known as AB 5, which then took that ABC test and applied it to California's workplace laws generally. So not just the wage orders, but all of the state's workplace laws. Now, notably, during the extended negotiations that led up to the enactment of AB 5, the app-based companies lobbied furiously for an exemption from that law in exchange and offered to do so in exchange for agreeing to some form of state-regulated collective bargaining and minimum standards for their sector. And this effort notably was encouraged by the state's Democratic governor, Gavin Newsom. And so there was a significant effort in that respect, but those efforts were ultimately unsuccessful. And here I want to talk a little, since this is sort of the first time this issue came up in a very significant way, I want to sort of talk about some of the legal issues involved. So one key challenge to any effort to reach such an agreement is our antitrust law, which is what we call our competition law in the United States. And that law prohibits businesses from collective price setting and group boycotts to enforce such price setting agreements. Labor unions are specifically exempted from these prohibitions by a labor exemption. But a 1990 Supreme Court decision strongly suggests that price setting efforts by independent contractors is per se unlawful under the antitrust laws, even if those contractors don't in fact exercise significant market power. And so as a result of this unavailability of a labor exemption to antitrust liability, any effort to have collective bargaining amongst independent contractors has had to focus on a different antitrust exemption known as the state action exemption, which permits price setting by private parties when they're closely regulated by a state to fulfill a clearly articulated state purpose. And I say all this because what we've ended up with are negotiations and discussions of state collective bargaining regimes that have very convoluted, rather than private party contracting as we're familiar with in the NLRA context, a very convoluted state regulated process in many of these proposals. And the reason for that is because of the background antitrust laws. This approach to have a state-regulated collective bargaining regime was highlighted by an early effort by the city of Seattle, this was back in 2015, to create such a regime for app-based drivers from Uber and Lyft, notwithstanding the fact that they were categorized by the companies as independent contractors. That effort, which was really the first effort to try to do this and to avoid the antitrust scrutiny, was struck down by a federal court of appeals on a technical ground under the antitrust law. They didn't say you can't do it, but they said you can't do it the way that Seattle tried to do it. So with that little cul-de-sac, I want to come back to the main narrative, which is that after efforts to reach a collective bargaining deal in California fell apart, the app-based companies then turned their attention to seeking an exemption from AB 5 by ballot measure. and they poured millions and millions of dollars into Proposition 22, which exempted the companies from AB5, and which was the majority of voters voted yes to enact Proposition 22 in last November's election by a pretty significant margin. So where all that leaves us is with a federal regulatory regime that's moving in one direction towards further regulation of app-based drivers, towards a more aggressive regulation of drivers as employees rather than independent contractors. And at least as symbolized by Proposition 22 in California, we have some state regulatory regimes moving in the other direction with regards to employee status for app-based drivers. To put more of a point on it, the same election that brought us Prop 22 in California was the same election that at the federal level delivered control of the White House to the Democrats, thus raising the possibility that we'll have new regulation at the federal level while all the state level experimentation is going on. So given the push and pull in those two different directions, it's not surprising that given their electoral success in the very blue state of California, it's not surprising that Uber and Lyft have redoubled their efforts this year in state legislative sessions in 2021 at lobbying efforts to strike similar deals to which they tried to strike in California prior to the passage of AB5. So while no such deal has actually been reached and enacted by any state legislature as of today, we can get a basic sense of the outlines of the sorts of proposals that are under discussion based on legislation that was introduced this term, including in Massachusetts and Connecticut, and the New York proposal, which has been previously mentioned by both Tanya and I, which was publicly released but never actually introduced as legislation. And if you look at these proposals in these states, the basic elements are as follows. In exchange, the basic trade-off, and this is what the companies want, is that in exchange for not treating their workers as employees under state laws, the company would agree to some form of quasi-collective bargaining. And as I've mentioned, in an effort to fit it within the state action exemption, in most cases, this quasi-collective bargaining takes place in the form of the parties negotiating a recommended agreement and then submitting that recommended agreement to the state for approval and implementation. So it might in fact be implemented as a state regulation. So if they agree to a certain wage rate, that could be implemented as a sectoral wage rate in the state, for example. That's one way it could take place. In its various iterations, this labor relations system would differ in key ways from the Wagner Act system that we're familiar with in the NLRA. For example, and none of these are consistent throughout all the proposals, but they do appear from place to place. Voluntary recognition of minority unions would be permitted, which is not permitted under the NLRA. Certain minimum terms of the labor agreement, including wages, unemployment insurance, workers' compensation, would be defined by legislation rather than bargaining. So certain pieces of this might be defined by the collective bargaining legislation itself, while other parts would be left up to recommendations negotiated by the parties. The union's representation fees would be paid by consumers directly rather than by workers to the union. That's something we saw in the New York proposal. And negotiated terms would either be extended throughout the sector to all companies by the state once they were negotiated between the primary parties, or they would be negotiated in the first instance by the parties themselves on a sector-wide basis. And that would happen through a state-mandated industrial or sectoral council. So these proposals have been highly controversial, particularly in New York in the last month or two. And I place the criticisms into three broad categories. The first is trade union concerns. Many view this form of quasi-collective bargaining as so top-down and state-managed as to be contrary to basic trade union principles of worker control. Of course, there are arguments on the other side. For example, given the nature of the app-based work relationship, it may be nearly impossible to organize a particular company on a majority basis without some very industry-specific rules. And the successful effort to organize and raise the standards of home care workers a similarly dispersed and hard to reach workforce over the past couple of decades provides at least a very loose analogy to why you might need special rules to organize in this sector. The second area of concern are really practical implementation concerns. Specifically, what can be done in trying to negotiate this type of legislation to guard against the situation where the app-based companies are exempted from state employment law liability on day one, but the worker protective aspects of the law are tied up in litigation for many, many years. And the background here is just the understanding that this sort of novel quasi-collective bargaining system is almost certain to be challenged in litigation on antitrust grounds, as I've described, on NLRA preemption grounds, on First Amendment grounds, along the lines of what was argued in a case like Janus, which was decided by the Supreme Court a few years ago, as well as likely a number of other constitutional and state law grounds. So even if the legislation, the worker protective aspects were ultimately to survive such challenges, it might be a number of years before they actually took effect. Of course, there's ways to deal with this concern as well by drafting, for example, the exemption from employee status provision that the companies want so much could be made non-severable from the worker protection provision so that they rise or fall together. But these are important practical implementation concerns. And then finally, there are global strategy concerns. There are definitely those who have argued, particularly in the context of the New York legislation, that now is just not the right time for state level experimentation, given the imminent possibility of further regulation at the federal level. Obviously, the PRO Act is an issue, and what it would mean for big Democratic majority states like California or New York to bring about a alternative form of collective bargaining when the PRO Act is being considered at the federal level. But even outside the PRO Act, given the strong possibility of new regulation by the DOL and NLRB, there's real reasons for questioning whether now is the time. So on the other hand, again, and this is sort of repeating something I've said before, there is a question of whether the NLRB representation process is so unwieldy in the context of, for example, organizing an Uber bargaining unit, that it would be better to work out a special company-specific collective bargaining arrangement at the state level. So there is that is certainly a reasonable debate. So some final reflections, and then I'll just wrap it up here. What's clear from these state proposals that we've seen so far is that although this is oftentimes billed as collective bargaining legislation, the other important aspect of this legislation is that it creates a de facto third category of workers that falls somewhere between employees and independent contractors, something that up to this point we haven't had in the United States. This is something the app-based companies have been quite open and clamoring for, but something that many worker advocates are concerned about as the first step in a slippery slope away from employee protections. In particular, there's a concern that if such a third category is established in this area for app-based workers who work for Uber and Lyft and similar companies, that other brick and mortar companies will start to move their work to app-based systems to try to take advantage of this similar arrangement with relatively lighter employment regulation. On the other hand, the proposals that are being discussed are third category of workers who do have union representation. So perhaps that's an important difference. But this tension is at the heart of the controversy over these proposals. And then finally, it's important to recognize as a political matter, whatever happens or doesn't happen at the state level will inform efforts by the new administration, the Secretary of Labor, the eventual NLRB majority, perhaps even Congress, to tackle the issue of employee classification of app-based workers at the federal level. This is especially the case because the issue of regulating app-based companies, unlike other labor relations issues, does not neatly break down along partisan lines. So whatever happens in a state like New York or California is sure to influence Congress through the Democratic Party at the federal level as well. So again, thanks for the time, and I look forward to your questions.
Thank you, Matt. That was an excellent presentation. We're now moving on from gig workers and app workers to a presentation by Mark Gaston Pearce of the Georgetown University Law Center Workers' Rights Institute. He will be speaking about utilizing university procurement to ensure the safety and equity rights of workers in supply chains. Mark is a panel labor arbitrator and mediator for the American Arbitration Association and FMCS. He is also a former two-term board member and chairman of the National Labor Relations Board. He previously taught at Cornell University School of Industrial Relations, and he is a graduate of Cornell University and State University of New York at Buffalo Law School. He has more than 40 years of experience in the practice of labor and employment law. Regarding questions, we don't have a Q&A chat box, so please enter your question in the chat box and we'll make sure to save it and ask it during the Q&A period. And I turn it over to you, Mark.
Thank you, Tequila. I'd like to congratulate the prior speakers, Matt and Tequila and Tanya, for a very informative presentation on each of their parts, and there is certainly a theme that follows with all of them. There's going to be something a little bit different with respect to my presentation, because my discussion will be dealing with an initiative that seeks to create change from the bottom up, or from the position of those who can influence change in a non-political way. I'm going to be sharing my my screen here. Can everybody see that screen okay without seeing my notes, hopefully? Okay. I'm going to be talking today about the Just Purchasing Consortium, which is a program that is being developed through the efforts of a coalition of organizations within Georgetown Law School, as well as University of California and Michigan, University of Michigan. The COVID-19 pandemic has shined a bright spotlight on the hazards and socioeconomic disparities faced by workers in food production chains. In an area of divided government and regulatory lethargy, neither large industrial food sector employers nor federal or state agencies can expect to protect the well-being and rights of workers. The Just Purchasing Consortium is a coalition of private and state universities, labor unions, and non-government organizations, which propose that major institutional purchasers require elevated standards on the part of food service providers, affording workers a collective voice on the job and a safe, equitable workplace. Well, why go with food purchasing? Well, because all the news is bad and universities consume a lot of food. Even before COVID-19's pandemic, jobs in the food processing facilities were predominantly occupied by immigrants and people of color. These jobs are among the most dangerous and least unionized workplaces, and subject to significant race and gender pay disparities. Under consecutive administrations, federal agencies like OSHA have consistently been underfunded and starved of resources necessary to enforce basic workplace safety standards. Clearly, reliance on federal and state regulations is not going to be the exclusive answer to provide protections for these very vulnerable workers. And as you know from the headlines and from our experience last year, COVID has really exacerbated these circumstances. What is the clinical and epidemiological nature and prevalence of occupational health risks? For each stage of the food supply chain, respiratory disease, foodborne and other infectious diseases, cuts, amputations, infections, chemical exposure, ergonomic and repetitive motion injuries, heat-related illnesses, and dehydration, bladder disorders from lack of bathroom breaks. According to the Food and Environmental Reporting Network, almost 100,000 workers have tested positive for COVID. 59,000 in the meat packing industry alone, 18,000 in food processing, 13,000 in farm workers. Almost 400 workers have died, with more than 2/3 being in meat packing. Here are the hotspots in these areas. As you can see in the center of the country, the supposed heartland, you're seeing where food processing and meat packing are prevalent. Those have been the hotspots for COVID and workplace infection. Death by company stats are compelling, considering the names common on the food aisles when we go shopping: Tyson, Smithfield. The risk of harm, the vulnerability of workers. This map shows the correlation between the concentration of vulnerable migrant workers and location of prevalent wage violations in Texas. As you can see down at the bottom, the violations are acute, and it's very close to the border with Mexico. Low wage translates to a vulnerable, marginalized workforce. The workforce is more often than not racialized. Since 2018, faculty and staff at Georgetown University, University of Michigan, and University of California have been working to develop a model whereby institutional actors can establish a purchasing code that will achieve transparency within their supply chains, many of which fall under the jurisdiction of food service management companies. What is the project structure? Well, we're starting up with a working group of university programs, administrators, and stakeholders. Not yet formal in terms of university endorsements, but that's where we're going. The working group today has administrators from 13 universities are participating. As detailed in, excuse me, we will collaborate in several small groups to work on law, health, and business. The steering committee, which it emanates right now from Georgetown, involves not only the Workers' Rights Institute, of which I am the executive director, the Harrison Institute, and the Kalmanovitz Institute, all of which are housed within Georgetown. Also participating are representatives of the United Food and Co- Commercial Workers, and 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 the United Food and Co- Commerci other entities within the Afl-Cio have agreed to participate. After we complete a purchasing code and recruit a critical mass of participation, we will create a formal consortium which with universities can affiliate. Monitoring will be worker-centered. Workers will trigger monitoring and investigations for violations and validate the accuracy of disclosure. I'd like to underscore the importance of having a worker involved monitoring system, because it's going to be essential to understanding how these various entities operate and what are the concerns as well as the priorities unique to those particular areas. What policies and groups do we seek to influence? We aim to raise the bar with 4 policy levers: a purchasing code, supply chain transparency, monitoring capacity, and remedies. The purchasing code sets general standards for treatment of workers plus specific protocols for the food chain and the farm and in processing facilities, warehouses and trucks, and food service venues, dining halls, retail stores. Supply chain transparency, beginning with the prime contractors and extending to suppliers, including specific facilities. We start with domestic supply chains, such as poultry and produce, and expect to add global supply chains, such as seafood. Monitoring capacity is the next aspect, which includes resources for independent worker-centered monitoring and investigations. Then finally, we'll have remedies, which include both contract remedies, withholding payments, worker remedies, health costs, back pays, resolution and mechanisms such as mediation and bid priority for incentivizing programs that benefit workers and protect and are sensitive to worker rights. Establishing a clear measure of transparency would work hand in hand with a system of independent monitoring, responsive to workers' concerns, with the capacity to initiate investigations for the Just Purchasing Consortium to reach the requisite scale required to substantially affect major industrial producers and make questions for workers' welfare a core element within the dialogue. This model is grounded in the higher education sector, but has the potential of ultimately expanding to school districts, hospitals, and corporate cafeterias. As discussed, the pandemic has highlighted the already existing abuse and worker injustices within the food supply chain. From the beginning of the process, practically to the table where we consume the food. Agricultural workers are statutorily excluded from the National Labor Relations Act. However, state and local protections are available in some jurisdictions like California. Agricultural workers, however, are not excluded from many DOL regulations, such as miscalculation, misclassification, and are not exempt from EEOC regulations and discrimination laws. The objective is to have this code that will require suppliers to adhere to a variety of labor standards, including occupational health and safety, and the right to free association and expression from their employers for their employees in the workplace. Provide workers an opportunity to collectively act and to discuss wages, safety conditions, miscellaneous unfair labor practices without reprisals. Because the initial focus will be in the meatpacking industry, workers are covered by the National Labor Relations Act there, as well as DOL, OSHA, and EOC, and much of the codes can track some certain aspects of these statutes. What will be the challenges? Well, obviously there are going to be many. Code development that universities are willing to embrace is going to be the first thing. Universities are commonly contracting out their food services to major suppliers. Nobody is doing their food service in-house anymore. There's a heavy dependence on suppliers for services and commodities in this area. It requires a compelling demonstration as to why codes and transparency is needed and how it can make a difference. Codes must be monitored in a way that does not impose unintended risk to workers. Current interpretations of the laws relate to protected concerted activity is very narrow based on Trump board interpretations. That translates to less actual and less perceived and less actual protections for workers who in a non-unionized environment seek to enforce their rights or to engage in a manner that they feel comfortable that they would be protected. Worker engagement will involve leadership training and reciprocal education. And I say reciprocal, as I mentioned previously, we need, those in the consortium need to understand what it is that is going on in each facility that is unique to that facility, how the injustices and the benefits and the priorities can be defined. As we need to learn from them about the priorities and the pitfalls of these unique workplaces. The design must facilitate worker self-determination and develop mechanisms of protection for documented and undocumented workers alike. Codes will provide methods of resolution such as dispute mediation in lieu of formalized complaints involving the involvement of state and federal authorities. We will need to engage workers in developing a purchasing code that sets standards, discloses supply chains, monitors compliance, and provides remedies. We need to create a dashboard to track occupational health and safety risks, cuts, amputations, repetitive motion injuries, and all the disorders that had previously been listed. We need to draft standards to fill regulatory gaps. And examples in poultry and meat packing include absence of standards set by OSHA, repetitive motion industry, heat-related illnesses, inadequate infectious disease protections, waivers that increase line speed, cuts, amputations, and so forth, food safety, risks. Now, I mentioned undocumented workers. The restrictions and the limitations that the law provides transcends just the previous administration. The narrow application, while the narrow application of cases involving protected concerted activity is problematic, those interpretations have the potential of being changed with regard to the Biden administration. But more significant and more permanent is the limitations that have been created through Supreme Court decisions like Hoffman plastics compounds, which made a determination that though undocumented workers are considered employees under the National Labor Relations Act, because they have undocumented status, they are not eligible for any of the benefits or the reparations, the make whole remedies that they suffered as a result of the unfair labor practices. This incentivizes undocumented workers' pursuit of their rights because the protection gaps expressed in a case that I participated in, Mizono's Maven Bakeries. We pointed out both in our concurrence, myself and then Chair Wilma Liebman, that Hoffman Plastics precludes payment of back pay to undocumented workers, chills the exercise of Section 7 rights as it sends a coercive message that you will assert your rights, you will be discharged and perhaps detained and deported. And that will kill any kind of efforts or desires on the part of vulnerable undocumented workers to seek justice. Solution exploration is going to be part of the consortium's task to develop remedies that incentivize the supplier to provide better working conditions, bid preferences, as mentioned, mediation, methods that will go around the law, methods that through the purchasing power of the universities can resolve matters to the benefit of all workers that have been affected. There is hope with regard to the PRO Act and to address the flaws and the current flaws in the statute. But as Matt had clearly indicated, the PRO Act has a tough hill to climb. So establishing codes and remedies from the perspective of the purchaser may be the better way or may be a viable way to go in order to deal with workplace injustice that transcend politics. Can this concept make a difference? What we must assume, what assumptions inform our work is this. Federal legislation through OSHA will not assure health and safety and food workers without significant long-term reform or standards and expanded enforcement capacity. Unions do not have the consistent political clout to overcome industry resistance to OSHA reform. While acknowledging that things look better under Biden, as was pointed out by Matt, this is a soup that is going to take a little while to cook. And then we don't know what's going to happen with the midterm elections and the resistance in Congress over reform policies and legislation. Industry will not adopt university standards unless we achieve a critical mass of universities that implement purchasing codes and monitor cost of less than 1%. A critical mass of universities will attract other institutional purchasers. But I have this picture here, excuse me. Our team member, Sabna Thrathahil from University of California has spoken about last year's tragic death in the Foster Farms poultry plant in California. And she provided an interesting anecdotal indication of how the university consortium could make a difference because of the purchasing power of universities. University of California is the 800-pound gorilla in terms of public institutions given the size and density of California. The Foster Farms circumstance came about. There was a lot of headlines with regard to that. The tragedy shows that 8 workers died after a COVID outbreak. Much bad publicity and lawsuits followed regarding the naked disregard of COVID-19 safety rules by Foster Farms, which was a food supplier of the University of California. How did the university respond? They had internal discussions with the university's sustainability officers, food service workers, groups, and sustainable procurement working group members regarding an appropriate response. Questions raised included, how are these types of issues generally addressed with suppliers? How does or can the University of California hold contracted suppliers accountable? Who is responsible? What can be done? If there isn't another supply source for the product, sometimes the supplier controls that particular section of the industry, and there may not be a viable alternative. What responsibilities did the University of California have versus the state and other authorities? Well, they decided to send a letter to 300 plus system-wide suppliers, emphasize the University of California's commitment to worker health and safety during and after the COVID-19 pandemic. Signed by the University of California's Chief Financial Officer and Chief Operating Officer. Letters reminded suppliers of the university's mission to serve society as a center for higher learning, that its sustainability practice policy has among its stated values the health and well-being of its students, staff, faculty, and other academic appointees, visitors, and suppliers. Suppliers were to commit and had to commit to provide safe and healthy work environments, including compliance with all relevant local, state, national, and international laws. No discrimination in hiring, salary, or benefits, no mental or physical harassment, retaliation, no infringement on freedom of association and assembly. And plus, there had to be compliance with all public health guidelines. University of California had the purchasing power to make a difference in their sphere of influence. Think what 50 or 100 universities and HBCUs could do to influence change in the condition of the vulnerable and the marginalized. How will this work be funded if we're successful? Well, already we have gotten a grant. It's a sizable grant from the Robert Wood Johnson Foundation, and we're in the process of seeking other grants. We're establishing university partners who can provide staff time to plan this project, but not to organize and sustain a national consortium. So we need to grow. Participants are applying to multiple foundations to cover their costs and organize this consortium. In the long term, we propose the consortium will get funds through dues or contract surcharge to pay for monitoring and transparency. We will have to employ experts in those areas in order to have best effect. It's a tough task and it has a lot of challenges, but the route that we're looking to follow is one that has had a degree of success with groups like the Workers' Rights Consortium, where merchandise and clothing has been regulated to make sure that it's appropriately sustainable and no workers suffer as a result. That workers' rights consortium's efforts were successful primarily with the engagement of a community that is desirous of change. And this is a good period in time for us to effectuate that. So I'd like to conclude here, and we'll gladly take your questions when the time comes.
Thank you, Mark. That was a really great presentation. Throughout our 3 presentations, there's a common theme of workers who are left out of or not properly served by existing labor laws and protective mechanisms. Our speakers have highlighted both legal, including court challenges and legislative challenges at the national and subnational level, as well as trade union options and civil society mechanisms to address these shortcomings in the legal and protective frameworks. I liked what Mark said about solution exploration. I think we've had a good establishment of what the problems are and exploration of different kinds of solutions. So now we're at the forum part of our forum, and we'd like to hear from all of you through your questions and comments on what you think about this panel and what options we have for the future. We're going to start with Jeff Wheeler. He is an international labor expert with years of experience in the government and adjunct professor at Georgetown University. He's going to make the first comment. And after that, we'll have Janice Palaci make a comment, and we'll open up the floor. Please put your questions in the chat box or raise your hand and we'll look out for you and include your comments in the forum. Thank you.
Well, thank you, Tequila. It's a very, kudos to DC LERA for putting on this panel. These are 3 very timely, mutually reinforcing and interesting presentations. And we see how some of these problems are pernicious and longstanding, and other things that are going on are really new, really new evolution. Matt's presentation reminds me of when I was a union organizer 20 years ago, and we were told by deputy sheriffs in rural Georgia that federal law don't apply down here. Well, yeah, it does. And the question is, how do you do it? You know, I guess I'd make just a quick comment and then a question for Mark on his presentation. One is, I think it's very interesting to see academics in application, taking the theory and applying it in practice. And the other thing I'd note is the purchaser-driven standards can really be a very powerful tool. And so we're moving from individual purchasers to large institutional purchasers, which I think there's a great deal of promise in that approach. One thing I and a lot of other people are curious about is the monitoring process. It's a very complex system. And the question is, how can you ensure, how is the process going to be set up to ensure that the standards are met? And are we going to see some written reports and research that come out of it that will be instructive for us, not just in the food purchasing, but how we could apply it in other large purchaser-driven standards? Thank you.
Well, the monitoring process is a significant challenge for the reasons that I articulated. The concern obviously is one where for it to have its effect, we'd have to have the cooperation of the workers. And to have the cooperation of the workers, they have to be protected. There are organizations that have engaged in professional monitoring systems that we're going to be consulting in order to evaluate how best we can have the best of both worlds, worker engagement at the same time as worker protection. I know in some facilities that are represented by unions, we have a better opportunity to develop a monitoring system through their cooperation. And some of the meat plant packing plants have union representation, and there are things that we can learn through their processes. But Jeff, that's where the rubber hits the road. Our development of a monitoring process that is going to be worker protecting too. We also are cognizant of the fact that bad working conditions for some employees' viewpoints are better than no working conditions, and we can anticipate that there may be circumstances where we know generally doing something on behalf of workers would be beneficial to them, but there may be a general concern that disrupting the current status flow may result in an organization or an entity completely changing its practices and denying workers their opportunities.
I was wondering if Matt or Tanya have any thoughts in response to Jeff's question.
Yeah, I was also wondering about issues of enforcement and how effective the university's consortium can be in terms of protecting whistleblowing. So our experience in the UK, you know, if I take the example of the Uber case, is we have a whistleblower who brought a case in 2016, and only in 2021 was it dealt with on the preliminary basis of employment status. Still no meaningful compensation for whistleblowing. If you were going to rely on the sorts of remedies that are available in the UK through the courts and tribunals, that would be woefully inadequate. So I was wondering what kind of meaningful protections one can put on the ground, because when you're casualized, you're so vulnerable to being dismissed. When you're a migrant worker, you're so vulnerable to deportation that it can be very difficult to get an accurate state of affairs. So I wondered how you can craft that. I know there's some experience in the Workers' Rights Consortium before in terms of products, but I was curious about your view on that.
I think it's more carrot and a stick from our approach, because we're using the implicit power of purchasing. We can create standards and practices that we would want the suppliers to buy into, and included in that process would be a remedies protocol, which provides for mediation and provides for consensual investigation in terms of what circumstances exist. And while it hasn't been fleshed out, a incentivized bidding process. If we have a situations, the purchaser has the ability to say, this is the kind of supplier we're looking for, based on what kind of worker rights track record they have. We may prioritize particular bidding based on how they treat their workers. We would engage in the kind of influence over the suppliers that government regulations may not necessarily be able to. Even though I would footnote that under DOL, particularly the Office of Contract Compliance, I believe they're going to be starting to kickstart programs for contractors with the federal government that will require them to meet certain employment standards with respect to workplace workplace practices in order for them to be eligible for government contracts. There's something instructive in that process that we would be able to utilize.
Matt?
I guess one more point, and that is the fist in the velvet glove is not only purchasing power, but it is also the fact that while regulations are woefully inadequate, employers do not want to have to be subject to investigations. The National Labor Relations Board, the majority of my career I worked with, irrespective of how slow and how ineffective the remedy process might be, the investigative process is one that that employers have to deal with, and that happens fairly regularly and rapidly. And hopefully, those are the kind of things that could be leveraged to good effect.
It's fascinating. I don't really have anything to add, but it's very interesting.
We have another question on procurement from Patrick McHugh. And Pat, do you want to ask your question? And then we can move on to have a question from Janice Balachi of the Wharton School.
Sure. I was just seeing, great presentation. All three are very interesting. It seems like in Mark's case that, in Mark's case, you're kind of doing standardization of sort of a high road approach. But in the Uber situation, it seems like public policy is kind of fragmented and uncertain. And I was wondering, to what extent do employers prefer a more fragmented, somewhat confusing state-by-state policy, or would they prefer some kind of standardization, do you think?
Is that to me or is that to Matt?
I think it
Sounds
maybe
like it's to
Matt
Matt.
and Tanya initially, just kind of, I think.
I guess like with most things, it depends, right? I mean, I've focused on the efforts that the app-based companies have made to reach deals with democratic legislators and to some extent with unions in states where they're at high risk of being regulated by the states, in places like New York and California. What I haven't focused on is all the many, many states where they've basically been able to sweep in and help write new statutes that clearly exempt them from most, them being the app-based companies, from most employment requirements. And so I think it depends. In many, many states, there are very favorable laws for these companies that basically affirm that their drivers are independent contractors. And there, I'm sure that, I can't speak for them, but I would imagine that that's sort of like the ideal scenario. But I think there's a recognition that at the federal level and in litigation, private litigation, there's going to be a continuing effort to show that their drivers are employees. So it's very hard to say in a general way in our system, in our very federal system. It may be different in the UK.
If I could jump in before Tanya about what I perceive to be the challenge in the US, and that is, as Matt pointed out in his presentation, where even in the best of circumstances, you have different agencies and entities defining independent contractors in different ways, and which leads to states, some progressive doing their own things that may be revolutionary to some extent, and certainly sensitive to the concerns of employees, and then other states going in the other direction. And then the overarching influence of lobbyists and billions of dollars being put into a circumstance that would would flip AB 5 to Proposition 22. And so much so that you had Democrats arguing in favor of Proposition 22, and civil rights organizations coming out thinking that Proposition 22 had to be had because AB 5 works against workers of color. It underscores the fact that you need a consistent regulation, a regulation that is overarching, that the courts will look to. Because if the courts are looking to the common law with respect to things coming out of the NLRA, and then looking to the statute for things that are coming out of the FLSA, you're not going to have the appropriate guidance necessary for employers to structure their business plans. And employers that are looking to avoid employee status are going to continue to exploit that.
Yeah, so I suppose that I think that platform employers have for quite a long time wanted to reap the benefits of the technical digital bonanza that seemed to be delivered to them. While they could exploit and leverage certain forms of uncertainty, they did so, and they enjoyed doing so, and they reaped large profits for various investors. And they used that to squeeze out other competitors, for example, normal taxi companies from the market. So I don't think that they were foolish. I don't think they ever expected that in the long term they would be left unregulated, but they've done fairly well over a long period of time. And so now I think what is happening is in the UK is that there is an attempt to leverage competitive advantage in other ways. So I think it's telling that the regional general manager for Northern and Eastern Europe for Uber has said that Uber is the only major player in the industry to provide drivers with a national living wage guarantee and so on. You know, so you play up your corporate image in that way. The other thing that you try to do, obviously, is capture regulation. In the UK, we had a Taylor review, which suggested that where there were stringent forms of control, you should have a presumption that there's an employment relationship and certainly regulate accordingly. It's very interesting that I saw Matthew Taylor's report as being very restrictive, very conservative, and highly problematic in a whole series of ways. But it was so regulatory that it seems to have been entirely ditched by the Boris Johnson administration. They're not interested in having him any longer as the director for labour market enforcement. What will happen, I think, is that this will be left to the courts and to the unions. And some people would say, given the current administration in the UK, that would be a good thing. But let's see what happens from here.
And now for a question and comment from Janice Balache of the Wharton School.
Well, thank you for all these very interesting presentations. And in light of time, I will just focus on the Uber type employer, what I will call the Uber type employer. What strikes me about listening to both, especially to Tanya, and is how different we are in the United States. Firstly, that we don't often talk about subordination or control outright. And you said right there at the end that there should be a presumption of employee status. And often courts act as if, oh, we're totally neutral. Is this an independent contractor or not? Instead of saying, why do we even have employment laws, plural, in the United States, both at federal and state level? And obviously it is a protective mechanism for working people. And in my mind, that should be the presumption that people are covered by it, and then the defendant could try to rebut that. But that's not the way the courts look at it. Secondly, in looking at some of the factors that they do in analyzing it, it strikes me that two that they point to are almost ridiculous in light of history. One is that the person can turn down work, can say, I don't feel like working today. I only say that because of those of us who are old enough can remember 50 years ago or 60 years ago, a company called Kelly Girls. And if an executive secretary was on vacation, the next week, executive would call up Kelly Girls and say, I need somebody. And then the person at Kelly Girls would go down the list and call up people and say, can you come in? Can you do this next week at this address? If the person said yes and went, that person was definitely treated like an employee. Nobody said because the person had the ability to be sort of flexible and turn down work, that somehow changed their status. I find that odd. Another one is whether Uber drivers, for instance, supply their own car. Many skilled workers who are employees in the United States supply their own tools. We're proud of having their own tools. Symphony orchestra musicians and major orchestras own their own instruments. Everybody thinks they're employees. So I say, is there historical and amnesia going on here? What's going on? And I could go on, and people should go read Hearst newspapers, the case from the 1940s, where the Supreme Court's trying to decide who's an employee. And by the way, says there's no bright line. And in writing something recently, I read a wonderful article written in the University of Michigan Law Review, written about the time the National Labor Relations Act was passed, reviewing who was an employee under common law, because the statute was about to be enacted. And it's a very interesting article, but it struck me that if we go back 85 years and really looked at what people were thinking about, it may be relevant to today. My final thing, though, is a factor that's often not mentioned in what courts look at things. Who is an employee independent contractor who doesn't set his own price, his or her own price? I mean, if you need something fixed at your home, your toilet's broken, so you call up Father and Son Plumbing. One way that you know it's really that person showing up is father or son is because they set the price for the work. If it's a company, Tonia was mentioning Pimlico Plumbers, I was thinking of, but in many cities now, there's one that has somebody like that with plumbers working for them. The plumber says, well, the rate, and then he takes out a sheet or pulls up his telephone and tells you. Everybody knows the difference. It's, do you set your own price? That makes you the independent contractor. If somebody's setting the price and pretty much, controlling many factors, to me, it's very hard to rebut the presumption that that person's an employee. And I'll end with just a case I really enjoy that is not a labor law case. And I'll have to put the name, anybody who wants it, email me, because I always forget the name. This was a case that went to the Court of Justice of the European Union. And it was after some country in Eastern Europe had acceded to the EU, and there was a schedule when various rights would take effect. So the person, to be blunt, was a prostitute. And she argued, and there were, you could establish a service, a business in another member state of the EU really fast. But the free movement of labor was delayed about 5 years. So she argued she was a prostitute. She was going to, I think, the Netherlands, someplace where it's legal, and she was setting up a business. And of course, the other states said, oh, no, she's not setting up a business. She's just a prostitute. And they gave a test, somewhat, Matt, like the ABC test, but their key one is who sets the price? Who sets the price? That was the absolute key one. And I think we're missing that. When you look at Uber, there is so much incredible control over the drivers. It's almost difficult for me to believe that a court can say they're not employees. So I will stop there. And I'll even leave unionization aside for a reason, which obviously is very important. If they were employees, they would likely be covered by the National Labor Relations Act. But really, employers are doing it to save a ton of money. Like, they're saving all sorts of things that employers have to do, and legal responsibility for certain things. And here we have companies like Uber that are going to be able to undercut other companies. So I look at Uber and say they have an app. Well, think about when taxi companies got telephones, and they could connect the end user with the driver by being the intermediary that was putting them together through the telephone. I mean, that was the big innovation of the day. So Uber uses an app, so what? I mean, it's very clear about the control that Uber has, and it's like an old-fashioned taxi company. I'll stop there. I don't have a question. I just, if anybody else wants to comment on that, and Matt particularly, because I think it's really the reasoning of US courts. Because of having to go to 50 state legislatures on who's an employee, I mean, it's really a mess. And because we can see how much companies like Uber can spend in lobbying to defeat such laws, I wouldn't go that route. I would try to say, can we somehow get courts to have a more enlightened view about why we have employment?
I agree with much of what you've said and wish our federal judiciary, was made up of folks who thought similarly. I'm not optimistic on that front at the moment, but obviously that is a big piece of it, and the state judiciaries too. But yeah, I do think, and it's something Sir Tanya had said, I do think in the long run, that the companies understand, and I think it's likely the case, that they will be found to be employers in the long run. But boy, there's a lot of room for mischief in the midterm, and so it makes legislation and legislative efforts so important.
Matt, you said something pretty interesting in your presentation when you talked about the dependent contractor, the other status that exists in Europe and in some provinces in Canada, where you have a hybrid between an employee and an independent contractor. But the concern, of course, is this going to be the slippery slope, as you stated, and have employers push more and more of their workers into that category, a category that provides less protection than was otherwise. I think the problem that currently exists, I think, Tanya, what you describe as the rationale that the courts used in the Uber case is nothing short of remarkable, because their baseline is employee status, and you demonstrate why it isn't, and based on what our understanding of employee status trumps. In the United States, there was always a parsing out. I mean, you go back to the slave origins of the exclusion of agricultural and agricultural workers from the protections of the National Labor Relations Act. Already there was an imposition of taking particular categories of workers out from protections for a variety of reasons. Then were the insidious ones of slavery, and then later these contractual arrangement. And to your point, Janice, when you have a app-based company that has proprietary algorithms where they can make a determination as to whether or not you're going to get choice routes based on quote unquote evaluations by the consumers, and you don't provide the contractor with the information in order to challenge or evaluate what it is that took them out of the mix, clearly there's a control issues that needs to be responded to.
I just wanted to reply briefly. It's lovely to see you, Janice. I'm looking forward to catching up in person one of these days. I did want to stress, of course, that the Uber case is simply about our LIMBY worker status. And so it has limited implications, but I do think that passage of the judgment from paragraph 94 onwards, which stresses the different forms of control, could be useful elsewhere. I hope that's influential. But I'd also say that the UK courts are interestingly political. So the last time we saw real court judicial activism was at the end of the 80s and the beginning of the 1990s, when we'd had Thatcherite Conservative government for a period of time. I don't think it's any coincidence that we're seeing quite strong, creative judicial intervention from 2011 onwards in the wake of the financial crisis. And it's kind of building in this context from our Supreme Court in the context of conservative government, where it's very clear that a lot of working people are living in poverty. So I think the courts are being creative here because there is no legislative engagement with the issues. And that will stay that way until we see some kind of electoral reform that changes the parameters for us.
I want to thank all of our speakers and our question askers and commentators for a really intriguing and wonderful panel. Pat McHugh will close now and share a few events for the future. And thank you everyone for participating and attending this webinar.
Yeah, thank you, Tequila, and especially thanks to Mark, Matt, and Tanya. What a very interesting and thought-provoking presentation. Tequila, thanks so much for coordinating this event, and also, Emily at National LERA to help us with in the background here, getting this event kicked off the ground. Thanks for those who attended the session, and just a reminder again, September 14th, we'll be having an in-person event at the DC office of the ILO, looking at the film 9 to 5. So keep that in mind in your mailboxes as that comes up. So again, thanks everyone, great session, and I hope the rest of your day and summer goes well.